Rule 4514, authorization records for negotiable instruments. No member or person associated with a member shall obtain from a customer or submit for payment a check, draft, or other form of negotiable paper drawn on a customer's checking, savings, share, or similar account without that person's express written authorization, which may include the customer's signature on the negotiable instrument. So you can't withdraw money from the client's accounts. You need the client to authorize that. Where the written authorization is separate from the negotiable instrument, the member shall preserve the authorization for a period of 3 days following the date the authorization expires. This provision shall not, however, require members to preserve copies of negotiable instruments signed by customers. FINRA Rule 4515, approval and documentation of changes in account name or designation. This rule requires that before a customer's order is executed, the account name or designation must be placed on the order form or other similar record for the transaction, and it addresses the approval and documentation procedures for changes in such account name or designation. This rule clarifies that with respect to any change in account name or designation that takes place prior to execution of the trade, the essential facts the principal relied on in approving such change must be documented in writing prior to execution. So this makes sense. If there's a change, that's a fairly serious change, right? A change to the account name or designation. The principal must sign off on it, approve such changes when in writing prior to execution, and document why they believe that it was a valid change. Firms can use electronic means to satisfy the approval and documentation requirements of this rule. This rule also provides that when accepting orders from investment advisors, the member firm may allow such investment advisors to make allocations on their orders for customers on whose behalf the investment advisor submits the order, as long as the firm receives specific account designation or customers' names from such investment advisors by noon on the next business day following the trade session. So as long as the firm receives specific account designation or customer names from such investment advisors by noon of the next business day following the trading session. This rule also clarifies that member firms may not knowingly facilitate the allocation of orders from an investment advisor in a matter other than in compliance with these two things: the investment advisor's intent at the time of the trade execution to allocate shares on a percentage basis to the participating accounts, and the investment advisor's fiduciary duty with respect to allocations for such participating accounts, including but not limited to allocations based on the performance of a transaction between the time of execution and the time of allocation. The knowingly facilitate standard means that a broker-dealer may not act recklessly or with knowledge in facilitating an investment advisor's breach of its fiduciary duties to its clients, and compliance with that standard turns on the facts and circumstances. So you should not knowingly facilitate that the investment advisor breaches fiduciary duty. Withholding tax. If an investor neglects or fails to include his or her tax ID or social security number when purchasing mutual fund shares. So we did say that if the client is opening up an account to buy only open-end mutual fund shares that are not recommended, they don't have to give the social security number. So if they don't provide their social security number, the fund is required to withhold 31% of all income distributions that would 100% would normally go to the owner as a withholding tax. However, so it's really interesting when you look at these rules one by one. When we look at Rule 4512, FINRA rules say if they're just buying open-end mutual fund shares that are not recommended, you don't need to have the client's tax ID. Thus, if you don't have the client's tax ID, the fund will withhold 31% of income distributions. But under the USA Patriot Act and under the anti-money laundering requirements of FINRA, you can't really open up an account without the client's tax ID. So it'd be very unlikely that you would ever be able to actually open that account up without the client's tax ID. So probably never does the fund have to actually withhold 31% of income distributions as withholding tax. You still have to know the rule. You also have to know that under the USA Patriot Act, which we're going to learn about in just a minute, the client's social security number is required. So it's interesting when all the rules don't exactly line up correctly. This chapter does have a few of those discrepancies where you do have to pay attention to the question, are they asking you under FINRA rules, under the USA Patriot Act, Securities Act of 1934? Sometimes there are different answers depending upon what they ask, how they ask it. Mutual funds will ask the investor to sign within the new account application a disclosure document attesting to 3 items. So it's like part of the application process. Under penalties of perjury, the social security number or employer identification number provided are correct. So you have to agree that that's true. See here, you just had to give your social security number. You have to attest that the investor is not subject to backup withholding, either because the client is exempt from backup withholding or the client has not been notified by the IRS that he's subject to backup withholding as a result of failure to report all interest and dividends, or the IRS has notified the investor that the client is no longer subject to backup withholding. So not everybody is subject to backup withholding. Hopefully not very many of your clients are subject to that. The client also must attest that they are a U.S. person or a U.S. resident alien. So if the whole question about backup withholding does not apply to the client, they can cross that out. It is this signed disclosure document, this certification, that allows the mutual fund company to avoid backup withholding. So like I said, in the real world, funds are going to do this. They're going to require the client sign this disclosure document. They're going to have their social security number. Thus, they're not going to have to ever withhold 31%. E-delivery. As part of the new account form, the investor can choose the e-delivery of all account documents. If chosen, this election remains in effect until revoked. E-delivery of all account documents is allowable under the SEC's Access Equals Delivery rules. Documents that may be sent via e-delivery include confirmations, quarterly account statements, tax information statements, proxy materials, annual and semi-annual reports, as well as prospectuses. In order for a client to opt in to electronic delivery, the investor needs access to the internet, a valid email address, and Adobe Acrobat, so they can download the reader for free. The investor who has opted into the electronic delivery of documents will always have the right to receive a paper copy of any account documents at any time upon request. So it's a great rule. I just always wonder how many people actually read them. I'm old-fashioned. I'm much more likely to read it if I get it in paper. Doesn't mean I get them all in paper, but I do still get a few in paper because I like them. I like the physicality of them. I don't know, maybe you'll read them online. Maybe your clients will read them online. You have to tell them that they are now available for them. It's an email that goes out to your clients. So most people, a lot of people today will just do e-delivery. Cost basis election, starting January 1st of 2012, mutual funds became required to disclose the investor's cost basis to the IRS. So these are, of course, in taxable accounts. As part of the account opening process, the fund will ask the investor which method they would like to use for cost basis reporting. Choices typically include an average cost basis, LIFO, FIFO, and some other methods of specific share identification. We talked about this within the mutual fund chapter. It just shows up on the outline for the test twice. Mutual funds will have a default method of cost basis reporting in case the investor does not specifically choose a method. The default method used by a mutual fund company is entirely their choice. There is no default required by law. The investor can always change the method for reporting by giving notification to the mutual fund company. Suitability documentation. If a customer is opening up a mutual fund account in which only unsolicited mutual fund orders are accepted, then suitability documentation is not required. So we talked about that in section 4. The application of the suitability rule is only applicable when a recommendation is made. If a recommendation is not being made, then you don't have to get all of that information. You don't need to procure the client's investment profile. That's the newer term that they'll use for suitability documentation. If a brokerage account includes recommendations made to customers, then firm-specific suitability documentations are required. Anytime a new account form includes a pre-dispute arbitration clause, which most of the time today it does, the actual clause itself must be highlighted and shall be immediately preceded by the following. So before the highlighted pre-dispute arbitration clause, it must say this. This is also a review. Doesn't hurt you to do a few things twice. Heck, I hope they ask you the easy questions on your test twice, right? So it must say this. This agreement contains a pre-dispute arbitration clause. By signing the arbitration agreement, the parties agree as follows. All parties are giving up the right to sue each other in court. Arbitration awards are generally final and binding. The arbitrators generally do not have to explain the reason for their award. In some cases, a claim that is ineligible for arbitration may be brought in court. Under FINRA's Code of Arbitration, the award may contain a rationale underlying the award if all parties jointly request an explained decision at least 20 days prior to the first scheduled hearing date. An explained decision is a fact-based award stating the general reasons for the arbitrator's decision. Inclusion of legal authorities and damage calculations are not required. It is the chairperson of the panel who is responsible for writing the explained decision. They get paid a little extra if they do that. So it is possible to get an explanation, but all parties must request it in writing at least 20 days prior to the first scheduled hearing date. NASD Rule 2510, discretionary accounts. This rule states no member firm shall affect with or for any customer's account with respect to which such member or his representative is vested with any discretionary power, any transaction of purchase or sale which are excessive in size or frequency in view of the financial resources and character of the account. No churning. We've talked about that. No member firm or registered representative shall exercise any discretionary power in a customer's account unless such customer has given prior written authorization to a stated individual and the account has been accepted by the member as evidenced in writing by a registered principal of the firm. So the client has to sign a discretionary form granting discretion, and a principal must accept it, signed off on by the principal. The principal of the member firm shall approve promptly in writing each discretionary order entered and shall review all discretionary accounts at frequent intervals in order to detect and prevent transactions which are excessive in size or frequency in view of the financial resources and character of the account. So The principal signs off on the new account so that you know, if you're the principal, you know that this discretionary account is in existence. So you approve it to open it. Then you approve promptly in writing every transaction, and you review the account to make sure there's no churning. This rule never applies to discretion that relates to timing or price. Anytime the client tells you type in quantity, they automatically give you discretion over timing and price. The order must be placed today at the best price the market will bear. So this discretionary authority, it's a power of attorney given by a customer to a specific person. So there's two types that we can have. There's a limited trading authorization, giving the member firm or registered representative the discretionary authority to make trades in the account until the authorization is revoked by the customer. Discretionary authority will also terminate upon death of the customer. It will also terminate upon the death of the person to whom the discretionary authority was granted. So if this discretionary authority is given to a specific registered rep and the registered rep passes away, the discretionary authority doesn't pass on to a new registered rep. It will cease, and then there'll need to be a new form filled out, basically. With limited trading authority, the registered rep can choose what to buy and sell in the account without having to ask the client every time, of course. Full discretionary authority is a much higher level of risk for the client, much higher level of risk. Gives the firm or registered representative a full power of attorney to make trades in the account as well as withdraw money and or securities from the account. Full discretionary authority may be granted by corporate accounts, partnership accounts, trust accounts, investment advisor accounts, or other fiduciary type accounts. Generally, your individual clients will not grant you or the firm full discretionary authority. They will grant a limited trading authority so that the registered rep does not have the ability to pull money or securities out of a customer's account. We have some rules as far as settlement of transactions under the Securities Exchange Act of 34. So under this act, we have SEC Rule 15C 6-1. It has to do with the settlement cycle. So remember, like I said, I don't expect you have to know the name of every single rule. Certain ones that I emphasize, then yes. So the settlement cycle. So we're still under here, Securities Exchange Act of 34. You will notice as we go through these that these rules under the Securities Exchange Act of 34 are going to be pretty much identical with the same settlement cycle rules that we have under FINRA rules. So that's good. So I'm not going to cover them twice. They're going to be the same as far as dates, times, how long, when, things like that. You'll see. So the day by which the transaction must be completed is known as the settlement date. This is the date by which the buyer must pay for the securities purchased and the seller must deliver them. Most securities settle on a regular way basis. So regular way. Regular way is T plus 3. Regular way settlement, T plus 3 business days to settle, to pay. So T, this is the trade date, T plus 3. So regular way. The settlement date for variable contracts, such as variable annuities and variable life insurance, is governed by the language in the contract itself, rather than by federal securities laws, since variable products are considered to be both insurance and securities products. So potentially a question on your test. Securities transactions generally settle under regular way settlement. There are, however, alternatives to regular way settlement, including the following. So we've got cash. So in a connection with a transaction for cash, delivery shall be made at the office of the purchaser on the day of the transaction. So cash settles same day. Settles same day. Sometimes they will ask, where shall delivery be made? At the office of the purchaser. Delivery made at the office of the, which makes sense, right? They're the ones buying the security. Delivery made at the office of the purchaser. Regular way, we already did. Regular way, delivery shall be made, same, at the office of the purchaser on, but not before the third business day following the date of the transaction. So I'm going to put that up here just so you have a chart with everything. Regular way, T plus 3 business days. Same rule at the office of the purchaser. Regular way, T plus 3. In connection with a transaction, seller's option. Seller's option. Delivery shall be made at the office of the purchaser, so same as before, on the date on which the option expires. So on the date, delivery made on the date the option expires. Except that delivery may be made by the seller on any business day after the third business day following the date of the transaction and prior to expiration of the option, provided the seller delivers to the office of the purchaser on a business day preceding the day of delivery written notice of intention to deliver. More common that you will have a question about seller's option, where does the delivery take place? At the office of the purchaser, when? On the date that the option expires. Buyer's option. Delivery shall be made at the office of the purchaser on the date on which, same as the seller's option, on the date on which the option expires. Buyer's option. Delivery made on the date the option expires at the office of the purchaser. Delayed delivery. Delivery shall be at the office of the purchaser on the date agreed upon at the time of the transaction. Delayed delivery. So at the office of the purchaser on the date agreed upon as of the time of the transaction. Date agreed upon in advance. So all of these, so these are the ones that are alternatives to regular way. So cash, seller's option, buyer's option, and delayed delivery. All of them, including regular way, delivery is made at the office of the purchaser. So for sure, a test question. So we have these rules. We have the Securities Exchange Act of 34, and we have FINRA, Settlement Cycle Rules. It's FINRA Rule 11.310. You're not going to be asked that. It's part of what's called the Uniform Practice Code for what is called book entry settlement. So delivery shall be at the office of the purchaser. If the purchaser maintains more than one office, delivery shall be made at the office where the transaction was effected. The party making delivery shall have the right to require that the purchase money be paid by certified check, cashier's check, bank draft, or cash. So these dates, this rule, where does delivery occur? At the office of the purchaser. Makes it sound like you walk over there or you have a courier deliver the securities to a person and that they give you cash in exchange for that. I suppose once upon a time under the buttonwood tree, that was how it worked. But today, instead of making physical delivery of securities or cash when settling securities trades, most firms will use what's called book entry settlement, which requires all transactions to be settled through a registered securities depository, such as the National Securities Clearing Corporation. Depository eligible securities are those that may be deposited at the clearing agency and where ownership may be transferred through computerized bookkeeping entries rather than through physical delivery. We don't actually physically deliver stock certificates or bond certificates anymore. Everything is done electronically, settled through a registered securities depository. So the National Securities Clearing Corporation is really the big one at this point. There's smaller ones, but that's the big one. If the rule under the Securities Exchange Act of 34 is the same as the rule under FINRA's Uniform Practice Code, then we know it's the same. The only thing that shows up that's new under FINRA rules is contracts that are due on holidays or Saturdays. You can't transact business on a weekend. So contracts due on a day other than a business day shall mature on the next business day. So if Monday is a holiday, then it'll mature on the next day. You can't deliver securities on a Saturday. We talked about the payment. So FINRA, as well as the Securities Exchange Act of 34, has the same payment rule that the person making delivery can require payment be made by cash, check, cashier's check, or bank draft.